We have a hypothetical for torts. This hypothetical came from Professor Miller, but we're just going to go over the facts of the hypothetical, and then we'll just go over our answers. But
yes, sir.
Before we go over the facts, I mean, you mentioned your thoughts before. You thought it was funny.
I did think it was funny.
Did you find it? Do you think you did a good job? I mean, we haven't looked at the answers yet, but do you think you got it right?
I think I hit many points. There are some points that I think I still could have hit for a more thorough analysis. But I think of the ones that I felt like I needed to hit, I did talk about them in some way.
How much time did you spend on it?
45 minutes.
I need to figure out how much time I spent on it.
And I wrote about 2 pages.
I spent 41 minutes. It's supposed to be 35 minutes long as far as our analysis goes. How much did I write? I have my word count. My word count was 830 words, which is kind of low for how much that typically takes me.
Yeah, I got 832, so we're in the same range right there.
Yeah. And I only did a page and a half single spaced.
All right, we're in good company then.
No.
So as for the facts of the case, before going in, thought it was a very Miller-esque hypo as far as like the facts. Sure. And I'm actually realizing that I think Miller outside is probably hilarious.
I think that's the case. Well, in class he's funny too.
Yeah. I think Miller is low key and high key pretty hilarious.
Yeah. As far as the fact pattern goes, we have 3 parties that are in question. We have Sabrina, we have Delbert, and then we have Carlos. So Sabrina and Delbert are law school students. They're prepping for a final exam. Sabrina's on call, and she is pretty much being taunted behind her back by Delbert, which causes her to be humiliated. And after class, she goes and puts her hand on his shoulder and says, "I wouldn't want you. You don't want to mess with me."
Yeah. The verbatim, "You're gonna wish you never crossed paths with me."
Yeah.
Which is, I think I've said that a few times after law school classes myself.
To other people.
Yeah, just a regular day in civil procedure, And then, so after that, that fatal threat by Sabrina, Delbert, I'd be upset too, and he starts to plot, and Delbert, in his plotting, goes, "You know what I'm going to do? I'm going to go in front of her house," because he knows where she lives. And sort of. You will see, sort of. And says, I'm just going to honk incessantly to really mess with her.
So that she doesn't get a good night's sleep, so that she doesn't do well in the final.
Yes, which I think also implies that this is not a weekend also. So, putting that out there. And so when Delbert, sneak peek right there, when Delbert goes to honk the horn, he's not in the right house exactly, and who comes out, Will?
Carlos. Yeah, so Delbert went to Carlos's house on accident, parked in his driveway, started honking the horn. Carlos comes out because he's ticked because Delbert's been honking his horn at his house for about half an hour. So he comes out and he fires his shotgun at Delbert's general direction, which causes some damage to Delbert's car. And the shot also goes through across the street, and turns out that Sabrina was living across the street. The shot goes into her house and hits her in the leg, and so she's bedridden, and she's not able to make it to class. And ultimately, because of that, Delbert gets the best score in the class.
Delbert gets his way. So the moral of the story is it still worked.
Sort of. Because now we need to figure out whether or not there's any potential torts that are involved in this case.
Yeah. Which is also just all the more funny because he studied for torts while committing a tort.
Yeah.
maybe committing a tort. Don't want to put anything, any other. So, walk me through what you were thinking, of like, what are some of the issues that you saw and potential torts that you saw?
Okay, so I actually think there are 5 potential torts, but there are only 3 that could be proved in a court of law. Mm-hmm. The first one is intentional infliction of emotional distress against Sabrina by Delbert, and that's going to be for his taunting in class.
Okay.
The second one is going to be battery by Sabrina against Delbert, and that's going to be her touching his shoulder and his fear of her mixed martial arts.
Okay.
The third is going to be trespass by Delbert against Carlos, and that's going to be him parking on the property and and honking his horn on Carlos's property. The fourth is going to be trespass of chattel by Carlos against Delbert, and that's going to be him shooting the gun and causing damage to Delbert's truck. And the fifth is going to be battery by Carlos against Sabrina for hitting her in the leg and causing injuries.
Nice.
But I would say those first 2 are not going to be found in a court of law. I don't think those are going to be considered torts. You can make the claim, but I don't think a court would find that as a tort. Yeah. And then 3 through 5 is going to be considered a tort.
So before we going into why those aren't torts, want to point out that you brought up a really good one of trespass to property, which I overlooked. And so I think actually acknowledging that too changes some of the analysis as well.
So what did you find as potential torts, and what did you find are what you would consider actual torts?
So I also said intentional infliction of emotional distress.
Against Sabrina by Delbert for the class stuff?
Yeah.
Cool.
Next issue, assault.
Okay. So you said assault, and I was saying battery.
Yeah, but I also alleged battery, which, I'll tell you whether I actually said that actually came out or not, but I also alleged battery.
Okay. I did debate about assault, but I did decide against it. So we can get into that.
I was part of me was like, why don't I just do battery and then lump assault with it? You know what I mean? But then I was like, you know what? Let's just do it. And then I alleged negligence, actually. I alleged negligence, and I went into approximate cause analysis, actually.
The only reason why I disagree with that is because we were asked to look for intentional torts, and negligence is not intentional torts.
Oh, wait. Potential intentional torts of cause of action. So this means that my analysis is all wrong. So, because of that, I think I'm going to be taking more of a backseat on this one and then kind of going through my analysis on the fly now.
Okay.
So, that is a bummer.
I could see there being some negligence there for sure.
Yeah.
But I think ultimately there's quite a few. As far as the negligence goes, I'm curious to see what parts of negligence and how you prove negligence and all that.
Maybe that'll just be a bonus part to be like, you know what? So here we go. Let's do intentional infliction of emotional distress.
Yeah, we can talk about the first 2 together for sure.
Yeah. So, what did you ultimately? What's your bottom line here?
There's not intentional infliction of emotional distress.
Okay, I also said.
And the reason why is that because it's possible that she can claim that for damages against Carlos for his battery against her. Mm-hmm. But as far as the classroom things with Delbert goes, it isn't because it's not extreme enough. She did not feel an extreme distress that caused her to actually have injury, and quite often causes you to actually fall physically ill.
For the exact same reasons I said that. I said the extreme and outrageous, and then I walk through how law school is competitiveness is nothing new. It's even common, so there's nothing unreasonably extreme or outrageous about that particular quote unquote threat. which I think it was a thing. So
Yeah.
I feel pretty good. Anything you want to add to that?
No, I think that's pretty straightforward.
Okay.
Let's talk about assault and battery.
Okay.
You said assault. I said battery. I was leaning it maybe towards assault as well.
Mm-hmm.
The reason for battery is because battery requires really two things. First is actual physical contact, and second is going to be physical harm that arises from that contact.
Yeah.
And so she put his hand on his shoulder, so that's physical contact.
Mm-hmm.
But I would not argue that he suffered any harm from that. If he did, he could do intentional infliction of emotional distress as damages, but I don't think that he suffered any physical harm, so there's actually no battery that can be involved here because one of the elements is not met.
Yeah. Oh, I'm just looking now. I also put battery and denied it as well for the same reason.
Okay.
And so I don't actually feel the need to add anything to that because I think...
So what did you say for assault then?
So for assault... I said, well, the two requirements are the affirmative act, and the conduct is extremely offensive to the party. And so, because I ruled out that it's not an intimate object, it wasn't. What are the other ones? I don't know, but the one that came up to mind here was the offensiveness, the extreme offensiveness, and I said that. Well, the affirmative act... I actually said the affirmative act is like the act of parking next to Sabrina's home and honking loudly in the middle of the night.
Okay.
And I said that that's obnoxious, but it's not extremely offensive.
So bottom line, did you find that there was assault or no assault?
No.
No assault. Okay.
Yeah. Though, now I'm thinking about it, I could have also placed that analysis with the classroom interaction as well.
Mm-hmm.
And so I think maybe if I were to do this again, I might, if I had extra time, throw like 3 sentences or something about that too.
About assault, how he could potentially fear battery coming at that moment.
From the hand on the shoulder, yeah.
Mm-hmm. Okay, as far as trespass against Carlos, you said you didn't go into trespass.
I didn't, but... Right, if I were to go back in time right now, I would actually argue that a trespass to property did happen.
Okay, and the reason why I argue trespass to property is because he was on Carlos's property, and the harm that had occurred on that property was the blaring of the horn. And disturbing the peace is something that is entirely plausible for trespass to property to actually find liability. So I think that's pretty straightforward. I think Delbert would argue that he didn't know he was trespassing because he thought it was Sabrina's house. I'm going to say that is not a proper defense because he knew that he was going onto some person's property, so he knew he was trespassing. He had that intent to trespass, so to speak, and so that transferred intent applies there toward the tort.
Or along the same lines, it was rather a mistake rather than an accident. And I think accidents are covered in that exception of trespass.
Mm-hmm. As far as trespass to chattel against Carlos, what needs to be shown for trespass to chattel is injury to the chattel that deprives the owner of the chattel some use of it. And you could argue that bullets hitting his truck and causing... defacing the truck through scratches could be a trespass to chattel. What's this bucket? Carlos would say that this was defensive property, but on the other hand of
the proportion of force that he used is not consistent with trespass to chattel.
Exactly, because he escalated it to life-threatening. And so his defense of property is not an applicable defense that he can use. And then finally, the battery against Sabrina. Did you talk about battery against Sabrina at all?
Battery against Sabrina.
From Carlos.
From Carlos. I thought about doing that, I'm not going to lie. And because I went the negligent route, I thought that subverted that because then it was this intervening thing. But
Oh,
anyway,
gotcha.
because my analysis is wrong. But you can go ahead and talk about it because I can see it, that analysis.
As far as a battery against Sabrina, what'll happen in this case, in my mind, is Carlos intended to injure Delbert. And instead he missed and hit Sabrina. So transferred intent is going to apply here. He intended to commit a battery against Delbert, and he, in fact, committed a battery against Sabrina, and it's a battery because there's physical contact, the bullets actually hit her, and there was harm causing her to be bedridden. Yeah. Missed her test, actually physically incapable of moving until she was discovered. Yeah. So I think there's battery. His argue is, I didn't intend to hit her, and transferred intent is going to negate that argument.
Yeah, because he did intend to do harm.
Exactly.
And so that would be really reminiscent of the Talmadge case, I believe.
Yep. As far as Professor Miller posted his outline. Do you want to go over the answers now, or do you want to go over some of the negligence?
Let's do it because we didn't do negligence, so it's not going to be harmed by reading this.
Okay. First question: Did Delbert commit an intentional infliction of emotional distress? We had talked about this. Did he have the intent to do it? No indication that he acted with the objective of causing her mental distress, but he did know to a substantial certainty that would be the result. But, so 3 questions. Did he have the intent? Was his conduct extreme and outrageous? And then, was her emotional distress severe? So, what is said is it's very likely that a court would not rule that it was extreme and outrageous conduct, and there is no indication that her reaction was severe.
Nice.
So, no intentional infliction of emotional distress. We nailed that. I think that would be 7 points for us.
The next one, did Sabrina commit battery or assault against Delbert? So, Miller had categorized them both, or put them in the same answer choice. So, she did not touch him with permission, but was the touching harmful or offensive? So, there's no indication of harm, okay, and I think we both conceded that. Would a reasonable person in Delbert's position consider the touching offensive? Likely not. Her comment, so we got those 2 points, I would say.
Yeah, definitely.
Her comment that you're going to wish you never crossed paths with me isn't an assault. It doesn't indicate a present intention to commit battery and is too vague for a reasonable person to interpret that way. So I would not get these points because I played assault in the wrong instance.
And I wouldn't get it because I didn't even bring up assault.
So we're both, no water there. Okay.
As far as trespass, did Delbert commit trespass of land against Carlos? Delbert intended to be on the spot that he had parked. The fact that he believed that he was on Sabrina's property is not a defense that can be made. So he is liable to Carlos for trespassing land, even though he didn't do any harm to the property. He was just annoying. So did you make? You didn't make the trespass, right?
Not on paper. No.
Gotcha.
Yeah. Next, Carlos committed torts against Delbert. Okay, so
there's quite a few torts that he committed against Delbert.
Delbert being startled by the shotgun blast constituted an assault. Okay, didn't get that.
I did not get that at all.
And whoops. I think this is instructive for me. I don't know if this is instructive for you, but now I'm seeing how itty bitty, because that fact pattern was not that long, but how much you can extract from all this. And so I think going into next hypos with stuff is interpret Miller's as dense. As Delbert was put in apprehension of an imminent bodily contact, Carlos clearly intended the noise from the shotgun would scare Delbert. 2 points. You want to do that one?
Sure. Was there a battery against Delbert by the car being shot and him being in the car and the car being practically him? This is not likely because it's different from an article of clothing or something that Delbert would be holding in his hand.
Right. And so this is the intimately connected to person. Okay.
And I totally forgot about that. I didn't make the battery argument as well, although I guess I could have. But yes, was this trespass to chattel or conversion? That's going to be the next thing. I didn't make the conversion argument because the party Carlos hadn't even taken ownership of the vehicle.
Yeah.
But I did make the trespass to chattel argument.
I also remember conversion being one of those, like, very, very rarely are things actually conversions, or that they're more likely than not trespass to chattels.
And what this says, did he intend or know to a substantial certainty that the car would be struck, and if so, then the harm is not serious enough for conversion, but trespass to chattel could be found.
Yes. So so far I am at the bottom end of this curve. Carlos would not have a good defense that he could use such force to protect his property to the extent that he was protecting property interest and wasn't acting self-defense. The force was excessive. Okay, so we pointed that out.
Yep.
So great there. So Carlos torts to Sabrina. Trespass to land. No indication Carlos wanted to have the shot go into Sabrina's house, but could be a case for transferred intent.
I did not make that argument.
Interesting. Carlos committed to. Oh no, you did make that argument. Did you not?
Not trespass to land from Carlos to Sabrina. I just made the battery through transferred intent.
I see. Oh, okay, yeah. Okay, which is, I think. Anyway, you read the next one. I think he talks about that.
Transferred intent would also lead to finding that Carlos committed a battery against Sabrina. As long as his actions towards Delbert weren't justified, the intent to assault Delbert can be transferred to the battery against Sabrina. I didn't think about the television as well, so transferred intent may also make Carlos liable for conversion of Sabrina's television. That's something we didn't talk about in the hypothetical, but one of the shells that went into her house
hit the HD television.
It hit the television.
So I didn't realize. So I thought Miller threw that in as a joke. So I actually didn't pay much attention to it.
I missed that completely.
And then last, this one is like, I didn't even think about this one at all. False imprisonment of Sabrina since she couldn't get out of bed due to her injuries. This may serve as a type of detention, but not the type contemplated by false imprisonment of action.
So we would have wanted to talk about false imprisonment, but that would have been a tort that did not actually happen.
Yeah.
Okay, well, I think there's lots of improvement for both of us, and it's going to come down to looking at the little itty-bitty details. But overall, thoughts about the hypothetical, as far as, like, how you feel about going into the final, not like how you perform, but how you understand how the final is going to look.
Yeah. I for one, I need to read the question, and then for two, I feel decent. I think I want to be able to recall elements quicker, so I think that's somewhere I definitely want to strengthen.
For me, this is what I was expecting more of Albert's test to look like, of a name that tort kind of thing. But I wasn't expecting Miller to go off with it as well. But Miller did go off with it with the list out all the potential torts that you can find here.
Yeah.
My issues that I think I need to see room for improvement is, one, time management. This is supposed to take 35 minutes, and it took me 41.
Yeah.
And I did not pay close enough attention to the details to pick up all the potential torts that could have occurred. I did get all the ones except for one that did occur, but there were several that I just neglected to point out just because they weren't as obvious as other ones.
Yeah.
So it's going to be finding those obvious ones that I think are essential for us to be successful.
I also think, and one last parting thing for like a takeaway for me also is like the way Miller organized his answers is that he did it
by person.
He did it by person to person, and I think that's something I'm going to adopt. Of like person to person, name that tort. Person to person, name that tort. And I think that's going to be helpful.
Yeah, because the way I had organized it was, I did it person to everybody, and so it was kind of sporadic, but Anyways, I think I feel good about that, and we'll leave it there.
Yeah.
Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.